Hey there, this is Wayne Barnes with Kaplan Bar Review. Have another one of our bar exam videos for you. Again, in the area of contracts, we want to look at a typical essay question in the area of contracts, and this is going to involve some issues. And again, what you want to do with an essay question is you want to read through the fact pattern, making note of what you think may be significant issues. You may not know for sure what's going to be relevant or not to you, know the full issues involved in facts, but you want to go through and kind of make mental notes about the high points, and that's what we're going to do now. Then we're going to think about some law, put an outline together, and then go ahead and approach this question. So let's just take a look at what we have going on here. It says that Dave Smith is an owner of Dave's Dairy Delight Store in Mount Airy, Maryland, and he's decided to sell, right? He wants to sell his store. He's ready to retire. He's ready to be put out to pasture, so to speak, not literally, but figuratively. And Dave Smith wants to sell. Well, looky here. We have Wade and Cindy Byer, who, oh, imagine that. Their name is Byer. You kind of know what they want to do. They want to buy the property, and they asked their lawyer to prepare this thing called a letter of intent. A letter of intent to purchase the location and other items from Dave. And this is the buyers and their lawyer have drafted a handwritten letter of intent. Now, what is the text? Well, it says the text is as follows. We, Cindy and Wade Byer, offer to pay, there's that word, offer to pay Dave Smith, seller, $350,000 for the improved commercial lot at 111 Main Street, Mount Airy, Maryland, by delivering $10,000 today, February 1, and the remainder of $340,000 by certified cashier's check no later than April 1. Notice this next sentence. A standard form contract will be delivered to seller within 72 hours. Very important. Okay, so it's one thing to say there's a letter of intent going on, but you know, the real contract's gonna come later, and that's gonna have some more stuff in it. That's gonna be really important, I'll bet you. Let's take a look. I'm play acting. I already know it's gonna be important, but you really would kind of need to think about that as you're going through the essay. So it says the buyers will pay all closing costs, and notice, I'm sorry, I kind of wrote over that, but the next sentence says the sale includes the seller's store's 15-foot plaster cow displayed out front along with all the store's fixtures. I get this cow is a big mascot of the store. They want that to come with it. It says all parties signed the letter of intent, but again, the letter of intent is an offer by the buyers, and it says the buyers then handed Dave their personal check in the amount of $10,000. What does Dave do? Does he go to the bank and cash the check? No, he just puts it in his file along with the letter of intent. Sure enough, a few days later, on February 3rd, Dave received the actual full contract that's been signed by the buyers, with a letter requesting that he return it, that he sign it, return it to them in the envelope. Now, next paragraph, it says Dave looks at this contract, he reads it, and you know what? He struck out the provision about the cow. He's kind of gotten attached to that plastic cow. He's not getting rid of it. So he strikes that provision, and he also struck out some provision. There were some fixtures listed for sale. He's like, I want to keep those fixtures. Maybe I want my, ice cream machine or whatever it is. Maybe he's attached to his cash register. We don't really know what they are. It doesn't really matter. But the point is he's disagreeing with some things that are in that form contract. Now he does physically sign it there in his own home, but does he deliver it to him right away? No, he places it, the contract in the envelope in his file along with the check. He's not sending it nowhere yet. He's kind of thinking about it, it looks like to me. He's not communicating yet. And in fact, later that day, Dave began to have second thoughts. He's getting cold feet, and he told the buyers, in fact, you know what, I no longer want to sell. Okay, now the buyers aren't too happy about this. They really got their heart set on that dairy store, and especially that 15-foot plastic cow. And so they get their letter, their attorney rather, to send Dave a letter. He receives it. The attorney for the buyers says a lawsuit would be filed against him for specific performance of this contract, claiming that there's a valid, binding, and enforceable contract between the buyers and Dave. And Dave has contacted you now, of course, licensed attorney. We can play act a little bit. You're not licensed yet, but it's fun to imagine that day will come very soon after you successfully pass the bar exam. But he's contacted you as to the potential outcome of the lawsuit to be filed against him. And it says, what advice would you give Dave? Explain your reasons. This is one of those classic, all issue, describe all issues. It's not really giving you specific, it just says, what advice do you give? And you kind of got to think about what are the issues here. Well, If you take a look with me, here's kind of the issues that I've formulated. And this one's really pretty straightforward. I mean, number one, well, first off, we know that to form a contract takes offer and acceptance. So I really think that's mainly what this is about. Was there an offer? Was there acceptance? So the first issue would be, have the buyers made an offer to buy the store and the land? And maybe what was the specified manner of acceptance contemplated, because the offer can state that. Then the second issue is simply, did Dave ever accept the offer? If he did, there's a contract. If he didn't, there's not. And it's really in this essay, I think, as simple as that. And so there's some subpoints we're going to want to look at. Did he accept by signing that letter of intent? Did he accept by putting the check in the file? Did he accept when he signed the contract but then struck those provisions, left it in his office? Did he accept by placing the contract in his file when he didn't send it to the buyers? Well, let's take a look. What's our rule on offer? Let's do that first issue. Have the buyers made an offer? Well, an offer is an objective manifestation by the offeror of a willingness to enter into a bargain that creates the power of acceptance in the offeree. So it's a manifestation, it's a statement, it's a willingness to say, hey, I'll do this deal if you will. I'm giving you the power of acceptance. Now, the offeror, you remember, is master of the terms of his offer. And so notice in the subpoint that the offer can specify the exact manner of acceptance required. And here, what happened? Well, the buyers, they created this letter of intent, but notice, don't get too thrown by that phrase letter of intent. It's an offer. It says so. We, Cindy and Wade, buyer, offered to pay Dave Smith this amount of money, $350,000. And how did they specify that Dave Smith should accept? Well, they say so. Hey, you don't got to sign anything right now, but we're going to send this standard form contract to you within 72 hours, and that we want you to sign. That's your way to signify that you accept. But I'm getting a little ahead of myself. That's the specified manner. But did the buyers make an offer? I think we can clearly say yes to that one for all these reasons we've given. They communicated in the letter of intent that they were offering to buy a particular land at a particular price. They specified how to accept. So issue one, check. Buyers have made an offer. Now, the key thing though is number two, did Dave ever accept it? Let's refresh what the rule is for acceptance. Well, acceptance is simply saying yes. It's an objective manifestation by the offeree to be bound by the terms of the offer. So, yep, I heard you. I heard the offer. I heard your terms. I'm going to say yes, right? It is expressing a willingness, an agreement, an assent. Yes, saying yes to the offer. Well, when you have that, you have a contract. Now, here's the kicker though. The acceptance has to be made in the right way. And in most contracts, notice that the acceptance must generally kind of meet two additional conceptual requirements. The acceptance has to generally first, it's got to mirror the terms of the offer. So you can't really be adding terms or changing things up. Now, if you do that, if you say, well, yeah, I'll do this deal except for I want to change this, and the other thing, like, oh, the price is going to change, or spoiler alert, the cow's not going. Well, that's not a mirror image acceptance. That's varying things, and of course we know that's a counteroffer. But here's the other thing which I think is critical here. An acceptance, when the humans talk to each other, there's no ESP, they have to communicate, right? And so the second element is that the acceptance has to be communicated to the offeror. If you're just sitting in your house by yourself with the lights off and you think to yourself, I'm going to accept this offer, but you haven't told anyone about it, that's not an acceptance, right? You have to communicate it to the offeror. Well, what happened here? Did Dave ever communicate an unequivocal mirror image acceptance? No, number one, he starts changing things. He says, I ain't selling you the plastic cow. I'm not giving you these fixtures. That's not a mirror image. That would be a counteroffer if he'd communicated. And here's the other thing. Did he communicate at all as far as an acceptance? No, he put the contract in his contract in his file. By the way, the letter of intent, it says he signed it, but so what? He's just acknowledging the offer. He hasn't agreed to anything. He put the check in his file. He didn't cash it. He struck the provisions about the cow and the fixtures. That's certainly not agreeing. If anything, that could be on the road to a counteroffer. And he didn't communicate the signed contract. He put it in his file. He's like, not so fast. He's not communicating an acceptance at all. What he communicated is that he wants out of the deal. And so I think the buyers are out of luck here. I think as Dave has asked us for advice, we can tell him, Dave, I think you're in good shape. You can hold on to the store for now and your 15-foot plastic cow. Give it a hug if you want to. You don't have to get rid of it now because you have not accepted the offer, and therefore we advise you that there's no contract, and let them sue. We'll be happy to engage you, have you engage us in the case, and we think it's a winner because you did not accept and there is no contract. So that would be another essay, and that'd be how you'd want to attack that one. Again, you read through, you make note of the important facts, start to think about the legal issues, make your outline, start applying it one at a time, applying the rules that you know to the facts, do some IRAC analysis, issue, rule, analysis, conclusion, and that is how you want to attack the essay portion of the bar exam. So thanks for watching. This has been another bar exam video from Kaplan Bar Review. If you have any questions, let us know in the comments. We'd love to hear from you. Otherwise, please stay tuned to this video channel for additional bar exam videos from Kaplan Bar Review.